first, I just want to thank everybody who's here joining us today. We know that right now is a very tough time for a lot of individuals, and as well as there's a lot of webinar fatigue. So we really appreciate everybody who's here joining today's webinar. My name is Teresa Anderson. I am the head of marketing and communications for Bureau Veritas North America. Before we get started with today's discussion, there are a few housekeeping items that I do want to go over that will help make sure things run smoothly. First thing, today's webinar is being recorded. We will be distributing today's recording following today's session. In addition, today's conversation is not to be taken as legal advice. These are merely considerations as you think through navigating the new normal for your business. In addition, all lines are muted. So if you do have any questions, we will be having a question and answer section today. If you look at the very bottom of your screen, you'll see a little icon that says QA. If you do have a question, please feel free to add it to the QA. Toward the end of the program, we'll try to get to questions, but I will admit we have a lot to unpack today, so we'll try to get to as many of those questions as possible. That being said, let me introduce a little bit about this webinar and how it got brought about. I know we are partnering with Hogan Lovells on today's webinar, as well as Bureau Veritas. It may seem like an unlikely partnership, but when you think of the heart of what both companies do, both of our goals are to protect our clients and help them mitigate risk. Some of you may not be as familiar with Bureau Veritas, so I'll give you the 30,000 quick overview of who BV is. Bureau Veritas is a leader in testing, inspection, and certification. We have been around for roughly 200 years. And most recently, we've been helping our clients as they restart their business and they navigate the new normal. We're helping them with safeguarding their businesses as they figure out the new landscape and keep hygiene and safety at the forefront. I'll give you a couple of quick stats as to the landscape of today's environment. There are 5 million confirmed cases of COVID-19 in the United States at this moment. There are over 4,000 lawsuits that have been filed. Lawsuits ranging from anything from wrongful termination to consumer exposure at a business to workers' compensation suits. Interesting factoid that I recently read, I think it's roughly over 450 lawsuits are specifically employee versus employer related. So we will be unpacking all of these different things and considerations in today's webinar. And we have expert minds that I'm really excited to introduce to you guys. So first person I would like to introduce, we have Heather Bush. Heather Bush is part of Bureau Veritas. She is our Vice President and General Counsel and Compliance Officer for Bureau Veritas North America. Welcome, Heather. We also have Michael DeLarco, who is the Office Managing Partner for New York at Hogan Lovells. He is the head of the Labor and Employment Practice of the Americas. Welcome, Mike. Next, we have Seth Cohen. He is a partner within the litigation department at Hogan Lovells, and he is a trial attorney. And finally, we have Michael Hefter, also a partner at Hogan Lovells and a litigation trial lawyer. I want to welcome you each to today's panel, and we're looking forward to a very, very interesting discussion. Welcome, guys.
Thanks, Teresa.
Thank you.
Thank you.
All right, so let's get started. As I said, we have quite a bit of stuff that we need to unpack today. So what I want to do is start the question with setting the landscape, right? We have all seen the headlines over the last, I would say, couple of months about a surge in lawsuits potentially being filed regarding COVID-19. My question to the panel is, what are you guys seeing out there, and what trends have you been able to identify that you can talk to us today about? And I'm going to start with Mike D first. So Mike, what are you seeing out there in terms of trends in litigation?
Yeah, thanks, Teresa, and thank you for having us today. On the employment side, I think the trend we're really looking at and we expect to see more of are claims related to leave of absences. COVID-19 has created new laws, not just at the federal level, but also at the state and local levels, and has really made what is already a complex area of law, which is handling a leave of absence for employees, that much more complex today. It's also a very sensitive issue for employers and employees. That is how to deal with these issues as they come about. Employers are really trying to be as sensitive as possible, but at the same time handling and running their business. And it's really, really important today to really have a grasp of what the laws are, how they apply to the workforce, and also take a practical approach to it, because morale is down at a lot of places. People are working remotely. Those who are being forced to come into the office, maybe they're deemed as essential workers. They're feeling different than employees who are able to work from home. And this is really an issue that we're going to see. And the reason I point out the morale issue and the feelings that employees have, these are the times when employees are more likely to file claims. And this is really why employers need to be on top of the leave of absence laws, reasonable accommodations, how to handle requests related to childcare, how to handle requests for time off. And more importantly, as we see in New York and some other places, we have laws in place regarding quarantine, right? That is, if you're in a certain state and you're coming back, you must quarantine for a period of time. We're in the month of August. People are taking vacation. People are traveling. Those offices that are opening or are reopening after Labor Day, this is going to be an issue that they have to deal with. That is, your employees have a right to take vacation. If they choose to go into one of these states that are identified as high-risk states by certain states in which they sit in, and they come back and they're an office worker, they can't work remotely, does the employer have to give them time off under federal or state law because they chose to take a vacation in that particular jurisdiction? So Teresa, that's some of the hot button issues that we see today that we think will be even hotter after school goes back in session and people return from vacation.
Thank you so much, Mike, for that insight. Heather, I'm going to position that same question over to you in terms of trends. I know you're inside counsel for us at Bureau Veritas. So what are you seeing?
I was actually going to pose a question to Mike, but I suppose I can answer your question and pose the question at the same time.
Perfect.
Because one of the things that's been interesting for me as a company that has employees in all 50 states is the states are changing their workers' compensation laws. And there's a presumption that if an employee has COVID, they got it at work, and therefore it's covered by workers' compensation. So that's one of the trends I see, and I'd like Mike to comment on that, and then happy to come back to fully answer your question.
Sure. Thanks, Heather, for putting me on the spot. Yeah, so we're definitely seeing some changes in the state workers' comp laws in particular. California, there's a presumption if an employee has tested positive to COVID and they were in the workplace, if they caught it in the workplace. A number of states are also moving in that direction. It puts the employer in a better situation, but also a difficult situation at the same time. In the sense of a better situation, an employee is covered under workers' comp, and that's really where their claim is going to be with respect to catching COVID-19. The more difficult situation is the employer has an obligation to investigate, to make a determination as to whether or not the individual actually contracted COVID in the workplace. And, you know, with the new Osha regulations that have come down, there has to be what's called a mini investigation, or what I term as a mini investigation, which means more than just asking one or two questions. So the issue that arises now is if you are in some of these states where there's a presumption of workers' comp and you conduct an investigation and your investigation finds that actually the employee did not contract COVID, how are you going to deal with that with regard to your workers' comp claim and your carrier? Are you still going to challenge the claim, or are you going to let the claim proceed, but at the same time on the OSHA front and on the negligence or some type of other claim front, are you going to use your investigation and your results of your investigation to protect the company against liability?
So thanks, Mike. And then to follow on Teresa's question, so the other flip side of that is the presumption of workers' comp law, and then employees trying to circumvent workers' comp where the damages are limited and making allegations of willfulness against their employer, and therefore having the opportunity to go outside the protections for an employer for workers' compensation. And that certainly is a concern of mine as an employer. And I think that leads certainly into the topics. The reason we're here today is how do you mitigate against that allegation of willfulness, whether as an employer or a business that has consumers entering your business.
Thank you so much, Heather. Seth, I'm going to go to you next, especially from a trial lawyer perspective. What trends are you seeing? Oh, you're muted, Seth.
Sorry about that, and thanks, Teresa. So I think that we talked about the fact that there have been a number of employment-related claims. I think that we've seen to date, really the two most common claims have been wrongful termination, which Mike D alluded to earlier, and also workplace safety claims are two that are sticking out to us. And the largest pocket of these filings we've seen so far have been in California and New Jersey to date. And entities that provide healthcare typically are making up a large number of these complaints too. With respect to wrongful termination, what we're seeing is that the complaints are being filed in response to a worker being terminated after raising a concern about a company not responding quickly enough to COVID-19, right? There are also cases that allege that a company terminated an employee after attempting to use certain cover-up or isolation materials that were mandated by medical professionals, or where employees were terminated after raising concerns that they were exposed outside of the workforce and they needed to self-isolate. Or where employees were terminated after the employee refused to break local, state stay-at-home orders as well. So just a quick example of a case that we've seen is in Minnesota, actually. The defendant, which was a sexual violence center, demoted and then terminated the plaintiff after the plaintiff repeatedly raised concerns about the center's response to the pandemic, which the plaintiff said violated executive orders requiring those who could work from home to do so. So we're seeing a lot of this type of thing, and most of these cases obviously haven't been resolved yet because this is brand new. But what the relief that the plaintiffs are seeking typically are injunctions, right, to get the employers to stop this sort of behavior, and in other cases, damages as well, especially if there are any sort of injuries, which we've seen in the workplace safety gamut. And I don't know, Michael Hefter, I don't know if you want to address workplace safety, or you want me to talk about that, or you have something else to discuss.
I was going to talk about something else, but you can go ahead.
So let me just briefly run over that then. So the majority of workplace safety claims revolve around companies, one, not implementing the safety protocols, right? Two, not providing PPE or other protective equipment. And medical, retail, and food processing plants. We've heard a lot about the food processing plants in the news lately. They're making up the majority of these claims. And where I'm sitting right now in New York, we make up the most of these types of cases in New York. And so I'll stop there so I don't go on too long and turn it over to Michael.
Thanks, Seth. Michael, can you talk a bit about what you're seeing?
Sure. So I guess for the purposes of this webinar, I'm Mike H. And then we have Mike D as well. But I was going to just take a step back and just talk about the legal landscape. And Teresa, you indicated the right number. We've seen over 4,000 litigations filed relating to CV-19. Certainly, employment-related claims are a significant part of those, and that's what we'll be focusing on mostly. But there are also all types of different claims. The largest group are breach of contract claims. We've seen a lot of force majeure litigation. We've seen a lot of insurance-related claims and around that. Those claims are being filed in state and federal court. They're most prevalent in California, New York, New Jersey, and Texas, and Illinois, I believe. But there's been litigation filed in all states. In terms of the employment litigation, also the type of claims just run the gamut: wrongful termination, whistleblower claims, unsafe workplace, retaliation, Family and Medical Leave Act, Fair Labor Standards Act, discrimination. So from our perspective, in advising clients, and from the Bureau Veritas perspective, and it also advising its clients, there's certain prophylactic measures and mitigating measures that everyone can take to sort of mitigate risk. But as trial lawyers, sometimes we're brought in, obviously after a claim is filed, a lawsuit is filed, and we're looking backwards retrospectively at what employers and companies are doing. So we have the perspective of doing those type of investigations, which show sort of the sometimes the right way of doing things and sometimes the wrong way of doing things. And I think we're all in this environment where, and I'm sure everybody on this webinar is in the environment of something so transformative and new, and trying to figure out what the right thing to do is. One last point with respect to the colloquy between Mike D and Heather, in terms of whether you do an investigation in the Osha context. It's always a tricky balance, strategic balance, because at some point you want to do the investigation so you satisfy your obligations, but sometimes you may be afraid as to what you might find. So therein lies the attorney-client privilege and other means of protecting that information as you navigate as to whether you should or require to disclose it.
Thank you so much, Michael. So let's unpack this just a little bit further. So I want us to focus more so on the liability mitigation perspective. And right now, businesses are facing risk on two fronts, right? So both from employees as well as consumers or others who may be visiting their business for temporary periods of time. We're going to start with Mike D on this one, but the question is how can businesses mitigate their legal risk as they open their doors to both their employers as well as outsiders visiting their business? So Mike D, I'm going to pass this one over to you.
Sure. So I'll talk about this on the employer-employee front. It's really important as an employer to really be up to date on CDC guidance and also the guidance that's being issued by the state and the local health governments, regulators, and also the governor's orders that are being put in place in the different states around the country. I think protecting employers from liability starts there, because none of us are an expert on COVID-19. The experts are those who I just mentioned, and that's the guidance that's being put out there that most people are taking a look at and saying, well, if you want to offer a safe workplace and you want to take reasonable efforts to ensure that workplace is safe, what do? Start with CDC, start with the health regulators, and put a policy in place that complies and follows their guidance. It's extremely important for an employer to put a policy in place that employees are aware of. That is, what they're required to do before they come into the office. Are they required to submit a health certification before they actually step foot in the office. If the employer is in the state of New York or some other jurisdictions around the country, the answer is they have to, because that is the law that we have today. Number two, if after they do a health certification, what other measures can they take? You could take temperature screening. The EEOC has already pronounced that temperature screening is permitted during this pandemic to protect the workplace. That's another step employers may take. They put policies in place with regard to social distancing, follow guidelines with regard to requiring individuals to wear masks in public places or public areas within the workplace, have signage throughout the workplace as to where employees are supposed to be walking so they're not getting into too close of distance with others. And importantly, employers just putting these policies in place, frankly, probably will not be enough. It probably will not be enough to take reasonable efforts. You also need to have some follow-up to those policies, making sure that people are actually enforcing the policies. Whether you have what I would deem an enforcer on each floor of your office, that he or she is responsible for, notifying HR or some other person within the company that they believe that certain individuals are violating the policy. That may be a way to proceed, but it's not enough to just put something in paper. It's not enough to just have sanitizing machines around the office. You need to take the extra step to ensure that people are actually following those policies. And then lastly, I could talk about this for an hour on its own, and I know others are going to address some of these other issues. But lastly, it's also really important to know what your business is. That is, for employees who can work remotely, whether you should continue to have them work remotely while the numbers of COVID are up in certain jurisdictions. There are states like New Jersey that have laws in place today that basically says you are not to have your employees return back to the office if they can work remotely. So you have to balance actually what your needs are, what the practicalities are, and you actually need to take action once you have your policies and guidelines in place.
Thanks, Mike, for that very thorough overview. Heather, I'm going to go to you next. I know as an organization, we've actually had a lot of conversations about this. So can you talk about this a little bit more from an inside counsel's perspective, but also from an organization like Bureau Veritas?
Sure. So I have to echo what Mike D had to say, which is compliance. Compliance is so incredibly important. If you put a procedure in place, but you don't ensure that your workforce or folks visiting your establishment are complying with the rules, then the rules are pointless. And you're going to end up in a risk mitigation nightmare. If you mandate mask wearing for folks visiting your office or employees, and then you're not doing it, then you could be held to a willful standard. Which could increase your level of damages and the type of damages that a litigant could seek against you. And then also as just for an employee relation, mechanism, you want your employees to know that you're there and you're protecting them and you're doing the right thing. For example, if you've been deemed an essential business and you could force your employees to come to work, but they're employees that can get their job done and not have to be at work, those employees should be left working from home. And we've faced that situation, internally in BV, and that's exactly what we've done. And the folks that have had to show up have actually expressed their gratitude that we're not further exposing them to potential infection by having less people in the office. So I think it's a good risk mitigation tool, and it's the right thing to do as an employer. And that's key to do the right thing as an employer and as a business that is consumer facing.
Thank you, Heather. Seth and Michael, I'm going to let you close out this question from especially a litigation attorney perspective. So Seth, we'll start with you. Oh, you're on mute.
I was going to say my middle name is Michael, so when he said Seth Michael, I wasn't sure if he was just referring to me. But so I think we've talked now about what employers are doing in terms of mitigating the risk. What about, states and government and legislators? And so far, a number of states and territories have adopted or enacted litigation protecting certain groups and entities from facing liability for claims relating to COVID. Most state indemnity laws are still pending, so this is all in the works, and so it's important that employers carefully review state laws as they're passed to ensure any liability protection that could apply to them. For example, in Louisiana, there's a law there that only protects restaurants that provide to-go food during the pandemic. So that's one thing to keep in mind to make sure you're checking what those laws are. A number of states, such as New Jersey, Massachusetts, Louisiana, Utah, Puerto Rico, Idaho, Oklahoma, Kansas, they've enacted healthcare specific legislation that protects medical professionals from liability for claims related to COVID. Other states are broader. For example, Oklahoma protects businesses that comply with federal and state regulations. As Mike D was talking about before, it's so important to follow those regulations. And in addition to healthcare providers, Kansas, for example, establishes protections from civil liability for PPE sellers and manufacturers. And so that's, again, that's important because you see state to state, there's different elements to this. For example, Louisiana suspended tort remedies for employees exposed to COVID-19 by their employers, quote, unless the exposure was caused by an intentional act. And then there's a number of states that have pending legislation that specifically protect an employer as long as they're acting in good faith and not recklessly, willfully, or intentionally exposing customers, clients, or employees to COVID. The reckless, willful, and intentional requirement will protect employers from possible negligence claims, while, if the employer acted in good faith to protect customers and employees. For example, in California, small businesses with less than 25 employees might be exempt from COVID-19 liability if they've, this is the law there, quote, implemented and abided by all applicable state and local health laws, regulations, and protocols. So again, that language comes back. But by contrast, Illinois' COVID-19 Immunity Act, that's what it's called there, provides that any individual, business, or unit of local government shall not be liable for civil damages for acts or omissions that result in COVID other than damages occasioned by willful and wanton misconduct. So there that is again. Pending legislation in New York and Pennsylvania seeks to limit civil liability of employers and employees for the spread of possible transmission of COVID when acting in good faith. So there we go again with the good faith lingo.
Thank you so much, Seth. Michael Hefter, we'll go to you next.
Great. So I would just follow up on that by saying, in light of what Seth just said, for those of you who work at companies that are multi-jurisdictional, have either offices or facilities or plants in multiple jurisdictions, it's important to understand that in each individual state law may require different things and may have different type of liability shields or none at all in these circumstances. I would also add, just from a litigation perspective, that and for somebody who's been in front of many judges and juries over time, judges and juries are commonsensical, and they look at things where people did sort of the right thing or what they would have expected. And so, we've seen cases that you sort of scratch your head. For example, there's been a wrongful termination case that's now pending. I forget the jurisdiction, but it was in an assisted living facility. The worker contracted COVID-19. Somebody noticed that he or she was not wearing a mask and they were fired. And lo and behold, in the complaint at least, it's alleged that the facility didn't provide any masks. There were no masks to be found. So, you know, in that sense, you know, maybe there was justification for the termination, but, you know, the allegation that there were no masks around may be that person's hook to at least survive a motion to dismiss at the beginning of the case. In addition, I just read this morning actually that there was a woman executive at a fairly popular national spin facility, bicycle spinning facility, who was terminated because for CV-19 reasons. Well, it turns out that she was also pregnant, and she believes that the CV-19 was a pretense to fire her, and now she's got pregnancy-related claims against the company. I don't know whether her employee knew she was pregnant or not, but you know, when companies are going through this analysis, you know, it's important to understand all the facts and the circumstances before taking action with respect to employees.
And I just want to add too, just a little separate from what Michael was just discussing, but since school is on everybody's minds, employers, employees alike, you know, New Jersey has also acted to grant immunity from liability to school districts and non-public schools from claims arising from COVID exposure. So that's an interesting piece there. I'm sure we can go on for days about schools and all that, but that's just something also in terms of the liability immunity piece of this.
Thank you so much, Seth. And you're right, that is extremely relevant right now as schools begin to think through how do they reopen their door to students, which actually is a good segue into my next question for you guys. But before I get to that question, I just want to thank everybody. I see there's some questions coming in from the audience. We will be getting to those very shortly. But with that said, the next question is really focused on, you know, how can companies and businesses reopen or restart their businesses safely? But beyond that, if they have never closed and they're starting to integrate, say, furloughed employees back in, what is the right way that they can do that as well as mitigate their legal risk? Mike D., I'm going to start with you here.
Sure. So, I mean, as I mentioned before, trying to get employees back to the workplace is a difficult task because not only do you want to make sure you're taking the appropriate steps that really protect the company from a liability standpoint, you also want to take appropriate steps where you're making sure that your workforce feels safe and they really understand that coming back into the workplace is as safe as it's going to be. I am of the thought that if an employee as of right now in high-risk areas can work remotely, that employers should continue to think about whether allowing individuals to work remotely is the right way to go. There are a number of considerations there. You need to be careful about who you actually choose to allow to work remotely compared to others. You don't want to be hit with a discrimination claim, or you don't want to be hit with an age claim. That is, you're encouraging certain individuals or telling certain individuals to continue to work remotely because you feel that they're in a high-risk category. That would be prohibited under the law. Same with individuals who may have disabilities or compromised immune systems. Employers can't require them to stay home. They too have a right to come into the office. But for employers who are opening up their office because they want to get a sense of community back in place and they want to give their workforce a place to come because they feel maybe the working environment in the office may be better for them than the working environment at home, so they make it voluntary. I think it's important that employers are very clear with their workforce. If it's voluntary, it's voluntary. What does that mean? They're not required to come in. And I think a way that you can really protect yourself against liability in those situations is not so much to have an employee sign a waiver. I know there's been some questions about whether waivers should be, that employers should require employees to sign waivers. The answer there is the waiver probably is not 100% enforceable. Certainly they can't waive workers' comp claims. Certainly they can't waive the right to, go to Osha and stop Osha from an enforcement proceeding. And more importantly, there's issues as to whether or not it would be enforceable because of the bargaining power. That is, whether the employee really had bargaining power as to whether or not to sign it. Well, but you could have your workforce sign a waiver if they choose to, and maybe use it more as a deterrent than as something that arguably would be enforceable down the road. But what you can do is you can require your employees to sign acknowledgments that basically says, we're opening up our office. Here are the guidelines that are in place. This is what we expect our individuals to do if they come to the office, and you acknowledge and agree that you're not required to come to the office, but you're coming voluntarily. That is something that employers can do. That goes to the whole reasonableness standard. It takes away, probably some gross negligence arguments, assuming that the employer is really getting that workplace along in line with the guidance that's being issued. And it's going to be very hard for an individual to argue that the employer should be held liable for something that happened to them with regard to the virus if the only reason they were there is because they chose to go themselves.
Thank you so much, Mike D. Heather, from a practical perspective and actually seeing this implemented, can you talk to us from an in-house counsel's perspective on what this looks like, how you actually get this started at an organization?
Sure. So, one of the things that we did at BV was we immediately implemented a crisis task force of the management team, and we originally were meeting twice a week. As things evolved, and now we meet once a week, and we talk about what we should implement, how we should implement it, what the best practices are. And Michael raised a point on the last question, which is, if you're operating in multiple jurisdictions and there's a bunch of different rules in a bunch of jurisdictions, how do you handle that? And the way we've handled it is taking the most conservative approach. So the most restrictive rules and regulations that are in one jurisdiction where we're operating, we've implemented them everywhere. For instance, Bureau Veritas as a policy has implemented masks mandatory in all of our facilities for all of our employees. That's to protect them. It's not mandated by all of the jurisdictions where we operate, but it was a way to, help mitigate the risk to our employees. And one of BV's mantras is social responsibility, and we couldn't think of a better way to be socially responsible than mandating mask wearing in all of our locations. We've also looked at, we are deemed an essential business for a lot of the services that we offer. And, how do we continue to service our client base while protecting our employees? And it's been a tough balance, right, between servicing our clients, but ensuring that our employees are being taken care of and we're not putting them in undue risk, if you will.
Thank you so much, Heather. Michael, Hefter, or Seth, do you have any comments on this topic?
You want me to go, Seth?
Sure.
Consistent with my comment before about, the diversity of the type of people that companies and clients that we have on the line here in the webinar, is that, each of you have unique businesses. What's appropriate for a law firm in Midtown Manhattan is going to be different for a testing facility that BV has around the country, which might be different from a meat processing plant or an automobile factory. So all that needs to be taken into account, social distancing, masks, hand sanitizers, and the like. Also, I would expect that, many of your employees are going to visit clients at other facilities, and you may have people visiting your facilities, and that raises a whole bunch of additional issues about compliance with health regulations, and that's something that needs to be considered as well.
I would add that, as litigators, we spend our lives looking backwards. Have the employers, employees, companies followed the directives, the laws, et cetera, that Mike D was talking about earlier. And so that's always going to come up later on when we're defending employers and companies. So our advice obviously would be to comply with local regulations, local and state regulations, and to put yourself in the best place in the future.
Thank you, Seth, and thank you, Michael. Okay, I want to pivot this conversation to something Mike D, and I believe Michael Hefter, you touched on this both a bit, and it's along the lines of reporting, right? So what are the reporting requirements for businesses as it relates to COVID-19, and are there best practices that businesses should consider as they're thinking through reporting? Mike D, I'm going to start with you.
Sure. So there's really two reporting requirements that employers really need to be familiar with. First is if an employee tests positive for COVID-19 and the employee is aware of it, the employer really has an obligation to report that to the local health authorities. This is something that was really pushed early on back in March, April, May. And it's something that the local health authorities are still requiring and requesting. One of the questions that always comes up is, well, what about, confidentiality with regard to these employee tests? We understand that the EEOC has, found that the identification, or has held that the identification of the employee really should not be provided to anybody who does not need to know. It should really be kept confidential. It shouldn't be spread. Well, the EEOC has provided guidance on this particular issue in the sense that they don't find that to be a violation if the name of the employee is provided to your local health regulator. Secondly, OSHA. There are OSHA reporting obligations, as I mentioned before. New guidance has come out. Employers have to conduct a mini investigation if they find that there's evidence that the individual may have contracted it in the workplace, and there's other elements that an employer must look at. They will have to report it to OSHA. It's very difficult for an employer who doesn't have a widespread outbreak of COVID-19 in a particular area in their workplace to determine, that absolutely this individual contracted COVID in the workplace, in particular if the individual is taking public transportation to work, not knowing where the individual has been, have they been to large gatherings, and so forth. So this is all part of the investigation, but those are really the two reporting obligations that employers need to really think about in the event they learn one of their employees has contracted COVID-19 and they were in the workplace.
Thank you so much, Mike D. Michael Hefter, I know you touched on this topic as well a little bit. So from a litigator's perspective, do you have anything you want to add about a reporting perspective?
Yeah, my point before is that, whatever report you are going to do, you have to remember that it's subject to discovery down the line in the event there's litigation. And so, the reporting process itself should be the investigation should be done with due diligence. It shouldn't be done, in a manner that somebody down the road is going to question whether it was done in a robust manner. But if it is done in a robust manner, it should be reported in a manner that reflects that it was robust, and that it should be done in a manner that if it were to be discovered in a litigation, that you would be okay with it being discovered.
Thank you so much, Michael. I'm going to transition over to something a little bit different here. And what I want to talk about now is what can businesses do to proactively begin thinking through if any litigation is going to come down the pipeline, what proactive measures can they implement now that would prepare them for more successful litigation outcomes in the future? And Seth, I'm actually going to start with you from a litigator's perspective, and then Heather, I'll go to you next.
All right, Teresa, you actually broke up for me there for a second. Can you just repeat that last part of it?
Not a problem, not a problem. So basically, what can companies or businesses do to proactively prepare in the event litigation could eventually appear related to COVID-19 issues? Are there policies they can implement now? What can actually be done before any litigation actually appears?
Yeah, and again, I think this goes to that we spend our lives looking backwards, and so this is actually, you know, what can we do looking in the crystal ball? And I think that this really just segues with everything that Mike D has been talking about. There's been so much coming down the pike with regulations, whether it's PPE or work from home or getting back to work. And I think what's critical here, especially from a litigation perspective, is that the courts are going to look to see whether the employers are acting in conformity with those policies and those laws. And so what's critical is that they need to be followed, and I would suggest to the T. You know, there's no exceptions in the sense of, well, it may be a little cheaper if we don't do this, or maybe we don't need to provide hand sanitizer, you know, near restrooms. Well, that's probably not a good idea, because a judge or jury looking back at that sometime in the future is going to question those decisions. And so I think that would be my big takeaway from that.
Thank you. And then Heather, I'm going to transition over to you.
So I think that one of the important things that a company can do from an employee perspective or from a consumer facing perspective is, and we talked about this a little bit, you know, you set up the SOPs, and then you make sure that everybody's complying with the SOPs. And a really, really good way to do that is to hire a third party, a consultant, or an auditor, or someone that can come in and take a look at your SOPs to make sure that they are meeting the minimum guidelines and that they're being followed. And I think that the being followed is, I can't impress upon everybody how important that is, because just because you put it on paper, if your teams aren't doing it, then it doesn't exist. And, you know, I know from an audit perspective, that's one of the things that people generally fail audits on is not having followed the SOPs that are in place. I think that's important. And, you know, it's funny, I read an article the other day that said something about 70% of consumers would change brands if they found out that the company that they were changing brand to had better hygiene protocols. So it's certainly something to be aware of.
Thank you, Heather. And I cement that comment you just made from a marketing perspective. What I'm seeing out there in the media are quite a few articles, right? In May, you saw a lot of brands announce that they do have protocols in place. Now you're seeing investigations where you're not seeing compliance. And in the digital age, people are taking pictures, highlighting those nonconformities. So I think
Teresa,
very important. Yes, Michael.
I don't know if where you're going next and whether we're going to go to questions or not, but there is another issue that we haven't discussed, but it follows on Heather's comment about SOPs and standard operating procedures. And this is not really a topic for this webinar, but I did want to highlight it because I don't know if there are any participants in the webinar who are involved in or who are employed by public companies. But we have seen lawsuits against boards of directors for breach of fiduciary duty based on the fact that the failure to have standard operating procedures was a lack of good faith at the board and caused shareholders harm. So I just want to throw that out there that we are seeing those lawsuits as well. And that follows from, good, for lack of a better term or a pun here, like good corporate hygiene, that a board should have mechanisms in place for reporting to the board that management is taking CV-19 seriously and has the appropriate standard operating procedures in place.
Thank you so much for mentioning that, Michael. That is extremely relevant for this conversation we are having. We are going to transition over to audience questions. So the first one I'm going to go to is, for individuals, what is a reasonable expectation of programs or responsibilities we can expect our companies to provide to protect us? Can you provide some additional examples? And actually, Heather, I'm going to start with you on this one from an inside counsel perspective.
I mean, we've talked about this over the last hour, but it's making sure that we're at a minimum following the local protocols. For instance, you know, Broward County, Florida, where our offices are, masks are mandatory. So making sure that folks that are entering our facility are wearing masks and following that minimum protocol is incredibly important. And if masks are mandatory, then you need to provide them to the employees so that they have them to wear. You know, the same thing with the social distancing. I mean, you know, we've cordoned off cubicles in our workspace so that people have to sit over 6 feet apart. So those are the types of things that individuals should be expecting at a minimum, is that their organizations are following the local ordinances.
Perfect. Mike D., any comments to add here?
No, I don't have anything else to add. I think we've covered this particular topic. The one thing I do want to plug is that, you know, this isn't just about protecting the workplace from liability. This is about making sure you have a workforce that's comfortable so they can do their job at the level expected, and you can run your business the way it was running pre-COVID. And one way that you can do that to really kind of figure out exactly, you know, what is your workforce thinking, is put together focus groups and have focus groups get together on a weekly or a semi-monthly basis to talk about what it is they are seeing that the company could do better to make them safer, and or to at least make people feel safer in the workplace.
To add to that, we actually sent out a survey to our employees to see what their level of comfort would be coming back to the office, depending on, you know, where geographically they were with the pandemic. And I think that's a great way to engage your workforce to feel empowered, if you will. And they should be empowered. I mean, this is their livelihood, and it's important. So I think a survey is a great tool.
I agree, and I think that aligns well with one of Mike D's initial comments in terms of how important employee morale is during this time, and also using that to help mitigate risk. Next question we're going to go to is also an audience question. So, are you think any claims against landlords for failure to modify their HVAC systems or for installing unsafe modifications to their HVAC systems? I'm going to pose this question to my two litigators. Michael, we'll start with you.
I wouldn't be surprised if that claim is out there. We haven't looked at all 4,000 complaints that have been filed, but I wouldn't be surprised, but I don't know the answer to that question, to be honest.
I do not know the answer to that either. However, what I can say, having a 2-year-old that we're contemplating allowing to go to school, we'll see, is that the school itself has replaced its HVAC system and has put in the MERV filters. So I don't think it's a requirement. Maybe it's a best practice. Maybe it's even better than a best practice. But it's certainly an issue that's out there right now. And so, as Michael said, there's litigation for everything. I'm sure there's an HVAC case out there.
Thank you, guys. Well, we're right around time now, but I want to give the floor to all the panelists for any closing remarks. Mike D., I'm going to start with you. Any closing remarks for our audience today?
I think just for employers as a whole, it's important to understand the changes in law because of COVID. HR departments, in-house legal, you know, in particular, if you have employees in many different jurisdictions, do your best to get up to date on the different laws. We are going to see more challenging situations after Labor Day when kids go back to school in certain jurisdictions, people return from vacation. There's going to come a time where there's going to be a need for more essential personnel in the office. And there are issues that are going to arise. And as HR professionals and as in-house counsel, you are only as good as your managers on the floor who bring the issues to your attention. So I think it's very, very important to train your managers on the new laws, train your managers how to spot issues that are related to COVID, whether it's leave of absence, whether it's some other issue that is directly related to COVID. Train them, because they're your eyes and ears, and you're only going to be able to advise and assist them and really try to protect the company against liability if they bring the issues to your attention, putting aside the policies and the guidelines and the SOPs that I'm sure most of you are already working on or already have in place.
Thank you. Heather, any closing remarks?
Thank you, Teresa. And I echo what Mike said about training your frontline managers to bring issues to you, because that's incredibly important. But the other thing from an in-house perspective that I see being a paramount issue is you have to know that you can't possibly know everything, and you need to be willing to rely heavily on your outside partners, whether it's a law firm or your insurance carriers or your brokers or any other subject matter expert that you have in your wheelhouse to go to and say, hey, new issue, never seen this before, can you help me with this? Don't be shy. Ask as many questions as you possibly can, because it's the only way we're going to navigate truly an absolute unknown. I've never faced anything like this in my career, and none of us have, right? So you need to be willing to go to an outside partner and ask questions.
Thank you. Seth.
Yes, thank you. I see we're right at the end here, so real quick. And what Heather just said, coronavirus is novel, right? What's not novel are crises. We've been dealing with this from the beginning of time. And so we need to respond to this crisis like we respond to other crises. And, as Mike D said, stay on top of the laws, get up to speed, and comply with those.
Thank you. Michael Hefter.
Yeah, just quickly, and following up on what Seth just said, all the news that we're being bombarded with and we're also actively following on websites can be exhausting. And we're also, many of us are displaced from our regular places of business. And so there's not necessarily a interaction the way it used to be. Which all that means is that I think you have to be diligent. The laws are changing, the regulations are changing, pronouncements from the health officials could change over time. This is not a static issue. It's an evolving issue, and everybody needs to just stay on top of it, as Seth said.
Thank you, guys. And thank you all to our audience for joining us here today. Thank you, panelists, for joining and for your insight today. Have a good one. Thank you.
Thanks,
Thank you, everybody.
Bye, everybody.
Bye.